Martial Law, our conversation with Marshall Criswell, attorney. This radio program intended for informational purposes only. The information does not constitute legal advice. The law constantly changes. The information may not be complete or correct depending on the date and your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. Because of these differences, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. Marshall Criswell certainly is one of those, and Marshall's on the line with us. This is the difference between Marshall Criswell and me. He knows what he's talking about, and I don't. Well, there's a few more differences there, too, when it comes to the law, especially. Marshall, good morning.
Good morning, Todd. I think you sell yourself short.
I don't know. I've already forgotten what our topic is supposed to be. We're talking about trusts this morning, right?
That's right, particularly living trusts.
Living trusts. Define that for me.
Sure. So a living trust is, the legal name for it would be an inter vivos revocable trust. Inter vivos, so what does that mean? You break it down. Inter vivos is Latin for during life. And revocable means that this trust can be revoked by the person that created it at any time. So these are trusts that you create while you're alive. They remain valid through your passing, but during your life you can change them, you can modify them, you can revoke it at any time. And these are an estate plan tool and I call it kind of a will substitute. Instead of having a will, you have a living trust which holds all of your assets during your life, and then creates a plan of distribution for when you're gone.
So, in what scenario would you choose to use a living trust?
Sure, and I'll just say I get this question all the time from clients. I bet approaching half of the clients that I have in for estate plan consultations, approximately half of people ask about living trusts, and that's because if you do any reading, if you go online and start reading about what do I do for an estate plan, or if you get AARP magazine, or you listen to certain syndicated national hosts that deal with money matters and things, that a lot of people mention living trusts and push living trusts. And one of the reasons for that is because in a lot of other states, living trusts are very, very advisable to have. Almost everybody with any type of asset should have one. Here in Pennsylvania, because our laws create a very straightforward probate process when someone passes away, living trusts are not necessary in very many situations. I would say, over 90% of the estate plans that I prepare are a will, power of attorney documents, making sure your assets that are jointly held are titled properly, your beneficiary designations are set up right, simple planning. So most people do not need one of these trusts. But to answer your question, who does? If you own real estate in more than one state, it is going to be advisable for you to have a living trust. Because if you have, you've got your home here in Pennsylvania, you've got a condo in Florida, or you've got a hunting camp in Ohio, or some vacant ground that you owned in New Jersey that your grandfather willed to you 20 years ago, whatever. Mm-hmm. You've got titled real estate in more than one state. Having each of those parcels of real estate owned by a single trust is going to greatly simplify the estate administration, the trust administration of those assets when you are gone. So that is definitely advisable. Another circumstance is the folks that are in second marriages, where you have children from a prior relationship, and maybe you want to create a trust that says, well, when I pass, I want my spouse to have full use of all of my assets in my home, but when we're both gone, I want my children from my previous marriage to inherit those assets. A trust would be good for that purpose. So where you're holding assets for an indefinite or a significant period of time before distribution, trusts are handy. But most of the time, a will and power of attorney documents are going to serve you just fine.
So when you are advising a client and they come to you, there probably are very few circumstances where you say, this might be something that you would consider is a living trust as opposed to some other sort of estate plan.
That's right. Like I said, 90% of people or more, that their circumstances and their goals can be met by having a will and power of attorney documents, which are a good, simple estate plan, which provide, obviously, for a situation where you become incapacitated and you have someone with power of attorney to step in to make decisions and preserve your assets toward the end of your life, and then a will, which provides for distribution of assets after you are gone. So very few people need more complex planning than that, but there are some that do.
In the circumstance you described before, which was multiple properties in different states, would the living trust that you establish for whatever that other state might be, say you mentioned New Jersey, would it apply only to the assets in that other state, or would the Pennsylvania assets be included in that whole pool?
No, and that's the benefit of having a trust when you own property in more than one state is the fact that you actually, when you have a trust and you own real estate, you need to transfer the title of that real estate. You actually need to deed the real estate into the trust. So if I own property in Pennsylvania, Florida, and New Jersey, as part of setting up my living trust, when we do the documents, we're going to also prepare deeds to transfer those properties into the trust so that when you pass away, all three of those properties are owned by one entity, the trust. They can all be administered here in Pennsylvania by the trustee that you've selected, rather than if you don't do that and you say you just have a will that says all my property goes to my kids, and you've got this real estate in multiple states, you're going to have to initiate some sort of probate procedure in each one of those states with the expense and time and aggravation that's going to create. You're going to have to do that is administer them each individually in those states. Whereas if you've got the trust set up, they are all owned by the trust, and they can be administered in one place.
Talking with Marshall Criswell this morning about living trusts, and one of the things that we often talk about here is when in your lifetime you want to do that. If I'm in my 30s or 40s and I'm in the situation where I want to set up a living trust or any other kind of estate plan, is it advantageous to do that as quickly as possible, as soon as you acquire the property perhaps, or is it okay to wait until you're later in life?
You want to start thinking about estate planning early. Unfortunately, I don't catch a lot of people early, right? I most of the people that are coming in to have consultations with me about estate planning are folks that are nearing retirement age or that are retired in later stages of life. But it is definitely advisable for when you begin acquiring assets, right? You begin working, you have a bank account, maybe you're thinking about that first house. It is very important to think about what's going to happen if I pass away. Also, when you have kids, right? If you start to have a family, part of an estate plan is providing for, who's going to be the guardian of these children if their parents aren't around, those kinds of things. So when you have kids, when you start acquiring property, you should be thinking about estate planning. But obviously, it's something that people don't think about until a little later in life.
Yeah, we understand that's the way people think because we're all invincible when we're 20 and 30 years old, Marshall.
That's right, and sometimes people think they are when they're 50 and 60 as well.
Yeah, well, that's like my mother always told me, you're not invincible, and I'd always say, no one's proven that yet. But I feel every day that, I am vincible. Mm-hmm.
Right.
But those are things that people need to take into consideration now. I would not guess that it makes a great difference the time of the year. For instance, we're in tax season right now. That in this case, that really doesn't have any implication when it comes to living trust, correct?
It doesn't. No, it doesn't. Maybe the only and there is a little bit of uptick in planning around tax season, and that's because people sit down and think about what they've got. Right, you get these 1099s in the mail. You're looking at your bank statements and your financial accounts, and you're thinking about what's going to happen with this stuff. And so just because it comes to the top of people's mind between the reaching the end of a calendar year and when you're filing tax returns. Yeah,
I would guess that is the case at the beginning of a year and then when you get to tax season, and then people tend to slack off on that, but they shouldn't. From what you're telling me, a living trust, if that's something you want to consider, or any sort of estate plan, now's the time. And I know that when they are considering that and they're searching around for somebody who's going to do that work for them, you offer free consultation.
Oh, I do. For any type of estate plan, for new clients that are want to have a consultation regarding estate plan work, the consultation's free. What we do is we always send out a questionnaire ahead of time. You fill out the questionnaire, it provides us with that, just basic family information and some of your assets and what your goals are. It gives us a good starting point for our conversation, and then when you come in, we meet and go through those things, and it also avoids you having to bring in a whole stack of bank statements and deeds to the house and all this stuff, because you'll have provided that the basic information up front. And the consultations, you can usually expect to spend about half an hour, 45 minutes going through everything, and hopefully moving forward with a plan to meet your goals.
So you might not be invincible, but maybe your estate plan can be. Marshall, if people want to set that up for you or with you, what should they do?
Call me at 724-465-5826. My office is in the R&P building, 655 Church Street in Indiana, or go online to www.westernpalawyer.com.
He is Marshall Criswell. Thanks for spending some time with us again today.
Thanks, Todd. Take care.
You too. It is the voice of Indiana County, WCCS 101.1 FM, AM 1160. FM, AM 1160. FM.